public who have joined us in the room today to not interfere with the proceedings, and as soon as the hearing is closed, please leave quietly. And I would, for the purpose of the recording the transcript, I'd be grateful if everyone could speak and ensure that they state their name and the role. And so for introductions, I'd first say my name is Deputy Hilary Jeune, and I'm the Chair of the Environment, Housing and Infrastructure Scrutiny Panel.
David Johnson, Constable St Mary, panel member.
Deputy David Wall, St Helier South.
Deputy Alex Curtis, panel member.
Deputy Steve Luce, Minister for the Environment.
Constable Mike Jackson, Assistant Minister for the Environment.
Kelly Wisehead, Group Director for Regulation.
And Kevin Pilley, Head of Place and Spatial Planning.
Thank you, and thank you, Minister, for joining us. In your last meeting, you stated that I only have limited resources within my team, I only have limited resources within the law drafting department. It's not as much as I might like to do it, I cannot do it all. And in light of this acknowledgement that resources within your department are limited, could you please describe how you're prioritising your workload for the remainder of your term?
Well, when we started as a government, we had obviously a limited amount of time, 2 years. And I think, like most people, we had aspirations of a number of things we'd like to do. But as time went on and as we made a priority list, if you like, of things, it became apparent that there were a number of outside considerations that had to be taken into account, and one of that, of course, is law drafting. And I think at one stage there may well have been upwards of 100 plus potential pieces of law drafting which needed to be done within government, and we quite clearly had to prioritise that. Time is a finite thing with law drafting, but we've come down to a list now with law drafters which we're fairly sure we can achieve, and it was important to make sure that we said what we wanted to do could be done. And we have got some work in train at the moment, law drafting instructions for animal welfare. We're obviously looking at planning reform, the appeals. There's a number of pieces of work, dredging and some fisheries work which we're going to do. And I'm very mindful of making sure that what we say we want to do, we can get done, because there's nothing more disappointing for me than to say there's pieces of work we're doing and not getting there. And having said that, there are some aspirations which I really wanted to get done, which are proving challenging. Things like, for example, the consultancy freeze, the consultancy ban has meant that we've had to reprioritise officers within the department to do pieces of work that were being done by consultants. That's all helping to make the situation more challenging. We've got a couple of officers not very well, and all in all, it is. We've got water and food, as I mentioned also. That's another couple of pieces of law drafting that we need to do. So we, as a government, are working hard with the law drafting department, and certainly as a department, we are talking to them continually about the work we want to get done.
And some of those areas that we're going to touch on further in this hearing, but PFAS, for example, wasn't initially a priority on your agenda, but has now been included, and you've specifically mentioned that you need to come up with further regulation on that. What specific factors have led to this shift in priority, and how has your position on PFAS evolved as a result?
Well, there's no doubt that PFAS as a subject and of interest in the island, and specifically in the west of the island, has been around now for a decade plus. And for a long time now, we've had members of the public asking for action. And I think when this government came to be, certainly we decided that it was something we were going to address, and we took it on board and very quickly realised that there was lots of work to do, and that other jurisdictions around the globe were starting to look at PFAS, and some already have taken action, and others are all starting to look at it very, very seriously. So we stood up a team. We have at least a dozen, if not more, officers within the department now working on PFAS. We've got a group chaired by myself and the Health Minister, also the economic ministers in that group as well. And we have the equivalent, I think it's 4.7 full-time employees working, that's the number that comes out when you crunch all the 12 plus. It's about 4.7 working full-time. We are committed to being open and transparent. We've got the international and independent PFAS panel working for us, producing 4 reports, 3 of which the third one's just about to be published. Those first 3 were on health. The 4th one will be on the environment. That's of great interest to me, obviously, as Environment Minister. And then the other thing is, in the very near future, we will have Qtly, a group that were commissioned 4 years ago initially to do some work for us. And over the last 18 months, they've been concentrating very heavily on monitoring and testing water around the island, specifically in the west. Their report is going to be issued very shortly. The next 6 months is going to be pretty busy from a PFAS angle. Lots of work coming out, independent work, scientific, professional scientific, really top quality work, and consequently from that, decisions to be made in water and things that would get returned to land and a whole load of stuff.
But it's interesting you're saying that there's a lot coming out. There's a lot we're waiting for, in a sense, for these independent panel to review. And I know that there are other reports that potentially are coming to kind of inform your opinion. But you've already said that you want to bring forward regulation, which I think is a new priority that wasn't there on the regulation list before. And so it's really trying to understand what you potentially have deprioritised, because this wasn't such intense, as you've just highlighted, that intense work, which wasn't necessarily seen before in our last hearing. It was only just starting to come about. So what has been deprioritised? What have you seen that has then been able to, that you've had to put this at a top priority when the reports haven't yet been published?
I can't know. I'm not sure if I know off the top of my head what's been deprioritised. I think we've just, certainly from my perspective, it's just a big additional piece of work that I've had to get through. When it comes to regulation and how we will look at limits for PFAS in water in the coming months, that's something that we'll do. But I mean, I could do that in a number of different ways. I could use guidance, as they do in the UK. I could use regulation, as they do in European countries, and there may well be other ways. Kelly, I don't know if they're trying to think of the different. It's not quite as complicated as it might be if I decide to set a new level of PFAS. I mean, I think I could issue guidance by order, could I?
Yes, Minister, I think because we're uncertain as to the type of regulation, so regulations come in lots of varieties, where we don't know what the level of resources or drafting, if any, is going to be required. The independent PFAS scientific panel has a public meeting on international regulatory standards, and they'll bring in experts from various jurisdictions around the world to give evidence about how regulatory standards are met in different jurisdictions. We will use that scientific research as a basis for recommendations and proposals for Jersey. And at that point, we will be able to forecast what type of resources across government would be required. So it's a little difficult to predict at this point.
I think that when I talk about big pieces of work, the environmental report 4, which the water bit will come out in the summer, and the complete report 4 will come out later in the year. But that will focus on jurisdictions around the globe that regulate in different ways and also treat PFAS in water in different ways as well. And there will be recommendations, finding recommendations that come out, and then it will be for me and the department to look at those to try to pick potentially a suite of treatments or a specific treatment. And then we'll, as Kelly said, there's a number of different ways we could enact that, whether by guidance or regulation or something else.
And I think we'll talk about that kind of treatment in a bit, but from what you're saying with the timeline, do you think that you will have enough time before PERDA to be able to implement those things that you will want to do in this area, knowing that so you've said the summer and then potentially the full report?
The big piece of work for me before the next election will be to look at where the new regulatory limits will be set for PFAS in water. as I say, the water section of report 4 will be with us during the summer. We'll be able to consider that before the panel issue their complete report, which will include food and other issues. So we will have the best part of 6 months, certainly, to think about how we're going to deal with regulation of PFAS in water. Obviously, there'll be time to discuss that with Jersey Water moving forward, depending which treatment method we might go for. There will be, quite large planning consequences because of the scale of land that might be needed. And we'll have to have some very fundamental discussions with Jersey Water about whether we use the 2 existing treatment works or not alternative. But I would hope that we will find time to do whatever is necessary to come up with some recommendations for new regulatory standards for PFAS before we get into PERDA. That's very important, I feel.
Thank you, Minister. And you were talking about Jersey Water and their role in the treatment, in the infrastructure treatment, and you said in the State sitting last week that you estimated a figure of about £20 million. Where has this come from?
Oh, I think off the top of my head, it's just a figure that's been bandied around for the type of cost in a very, very roundabout way for activated carbon, granular activated carbon treatment of the sort of size we might want. And I'm not sure if the number didn't actually come from Jersey Water themselves, but I would stress that £20 million is a very rough approximation. We're not at a point yet where we know the treatment works we're going to need. We haven't decided where they might go. I mean, the geology, topography of the site that we might use could be hugely challenging. So that's just a sort of an indication that at the moment it might be around for the 2 treatment works, 40-50 million pounds. There are other alternatives that I'm sure will come out, and they could be more expensive still.
And who do you think should be paying for that 20 million?
Well, that's a very good question, Chair. And I certainly have said to Jersey Water, the most important thing for me at the moment is to get the regulatory standards and start to work towards them as quickly as we can. And I think I've said we'll worry about who pays for it at a later date. It may be, and I'm sure it will be, a discussion for government to have with Jersey Water. If Jersey Water were charged with recouping all the cost of those treatment works through their current billing system, obviously the consumer will pay. But I think that there must be a discussion to be had with government about how the funding of these very large infrastructure projects for the benefit of islanders should be dealt with, and that will be for another day. I'm not trying to kick the can down the road, but I think there are a number of options where we can work with Jersey Water to see the best way forward for islanders.
Could I just add,
Yes.
Minister? This afternoon we have a public meeting online of the PFAS scientific panel, and Jersey Water will be presenting their water treatment options. I haven't seen that presentation ahead of time, so I'm not sure if that will include costs, but I know that they have been working on costs, so it might be that this meeting this afternoon will bring to light that information. Once that panel meeting minutes have been approved, I will share with Scrutiny.
I think it's important to stress, though, that the £20 million or approximate £20 million may well have come from the cost of building other plants in other jurisdictions, and I'm thinking particularly about Australia. It may well be that in Australia, and I don't know because I've not seen it, but it may be they may have built on a vast area of open flat land adjacent to, reservoirs or what have you. I think it's fair to say that wherever we build treatment works in Jersey, there's going to be challenges because they need to be a certain height above sea level, and we're talking about valleys, hills, and major infrastructure complications.
And I believe that there is no definitive scientific consensus on the best method for PFAS removal. So how will the government determine what's the most effective and safe approach if you're especially given a wide variety of recommendations from
Well,
the
this is where
panel?
the independent panel come in. This is why they are completely independent of government, why they're experts in their field, why they are looking across the globe for the different methods and where certain methods have worked well, etc., etc. And they will come back to us during the summer and say, this is what you have around the globe as options. You can use activated carbon, you could use ion exchange, you could use, reversal. There's a whole suite of options. And it may be it's a combination of various options which get to where we need to be. But the panel are charged to go away and do all this research. They're experts in their field. They're going to look all over the place and come back with findings and recommendations for me and for the department. And at that point, we will have to look at what they say. We'll have to talk to Jersey Water, and we'll have to consider a range of options and come up with a solution. I mean, I'm sure that this panel, your panel, would be sort of included in discussions about that. This is all open and transparent. All their evidence will be out there for everybody to see.
Absolutely, and I've attended many of the public hearings, meetings so far to gather the information to help the panel.
Just one quick question, just striking me here is, what is the relationship between the independent panel, Jersey Water and government? I mean, how does that all work together? Because my immediate reaction is Jersey Water are the water provider, so do they not have their own set of experts who will be trying to resolve this issue? I mean, are they proactive, or do they just wait for government to come along and go with their independent expert and go, this is what you need to do?
The relationship between government and the independent panel is exactly what it says on the tin, completely independent. The only time I've met the panel or met the chairman, didn't meet him face to face, met him online, and the only time I spoke to him about the production of the water report early, before the complete report 4 was published in the winter, towards Christmas. And I said how important water part of it was, and could the panel think about producing the water section of the environmental report early so we could get on with it. I have deliberately stayed away from the panel. They have public meetings, like for example, they're having a meeting this afternoon. I know roughly what they're going to discuss. Kelly's just said it. But I have no input at all. It's really important that government keeps this big gap between themselves and the panel, so we can get to the end of the process and say we have had no input. They have gone wherever they liked, and they researched whatever they wanted to do to come up with their independent advice for us. Obviously, they're appointed, they're experts. As regards Jersey Water, I don't really know. I couldn't put my hand on heart and say how they interact with the panel, because I don't know what the panel do. But
I could take that question if you like,
okay.
Minister. So Jersey Water are invited to, as an expert, to input into the evidence for the panel. So today, you're correct in saying that Jersey Water have their own scientists and their own experts advising the company and working up different treatment options and what each of the constraints of those treatment options could be. They will present that information with their experts to the panel. The panel will listen to them as well as other international experts who have done treatment facilities around the world. Once the panel will just have a discussion around all of those different combinations of treatment options, and then obviously what is possible in Jersey because of the constraints of the land and also the current treatment facilities that we have. And that's how the panel would arrive at their recommendation. It would be in contribution with Jersey Water as an expert, as well as other international experts on water treatment options and other experienced experts where treatment options have been brought online and what experiences they have had. So all of that information will be included, as I said, discussed in public, minuted and included in the report and made public before the recommendations arrive in summer.
And with this discussion now that is seeming to be set, that will have to be something done. You are looking at regulation changes, or however the form that will be. You are starting to discuss with Jersey Water and others about potential infrastructure that will extract PFAS. This has to be then a recognition that it's leached out of the plume area. This is an island-wide issue rather than the specific plume area. Am I correct?
well, it's an island-wide issue in as much as there's almost certainly people outside of the plume area who have had blood tests taken independently who show levels of PFAS not dissimilar to people who live in the plume area. But one of the other things that's really important about the independent panel's report 4 on the environment is that they're also going to look at other methods or other ways that people can ingest PFAS into their bodies, and specifically we're talking about food. And I don't know what the results are going to be, but I think we're going to find that there's a number of issues that we need to consider when it's how do people get PFAS into their bodies. We are conscious that there's a number of people from outside the plume area who have tested high. We need to understand their history. We need to understand where they've lived, what sort of water they've used, what sort of food they've eaten, that type of thing, to build up more of a sort of a database, if you like, to try to work out how PFAS is getting into people's body. But there's no question that it's wider than just people living in the plume area.
If I may
Yep.
just add, Minister, there is a very different distinction between the issues of the plume area and what we were talking about, water treatment supply and the public water. The public water supply is within safe limits of PFAS as current international standards. So the work of the report 4 and the PFAS panel will look at where the international limits are going in the future, not where they currently are. So where are they heading into the future, and how might we meet changes in the future? Very distinctively different to the hotspot or the plume area, and which is treated completely separately.
Okay, thank you for that. And I suppose my last question is, of course, that I believe, because we haven't seen it, that the agreement with 3M, who were the ones supplying the foam that caused in that plume area, was that they did a cleanup in that specific area. So they did some work. Was that true, or there was work done at that moment in time to try to clean up that, kind of contain the area around?
There was remediation work done at the airport some time ago.
Will this report by the independent panel look at if that was actually effective, or if that actually failed in its objectives?
Yeah, but the straight answer is absolutely yes, it will, because our cadres have been charged with doing a lot more sampling than we've done previously, and when their report comes out, I'm very hopeful that they will be able to say the extent, or I mean, hopeful might be the wrong word, but they will be, I hope, telling us if the work we did at the airport was successful or not. And quite clearly there's still PFAS in the plume area, but there's a lot of hydrogeological understanding that's going to need to be looked at. I know it's going to be a large report, several hundred pages, and most of it's going to be scientific, so we're going to be looking for officers in the department to give us a non-technical, I'm trying to think of the word, non-technical summary of that when it's published, and we would certainly hope by the middle of May we'll have something to discuss, really.
Thank you. And obviously the panel thinks this work is very important. So just to give you a heads up, Minister, that I believe we would want to hold a standalone hearing on PFAS in the coming months, I think, as the independent panel reports come to light in these other reports to help see any recommendation.
As I said previously, I think the next 6-9 months is going to be pretty busy and intense from a PFAS perspective. We have our cadres. We've got report 3, the final health recommendations and how we deal with that. We've got the water report, which is going to be really important in the summer, and then at the end, towards the end of the year, but certainly for the end of the year, the final report 4, which looks at PFAS in the environment. There will be some other issues there which we'll need to discuss. By this time next year, we will have done a huge amount of work on PFAS and hopefully reach some conclusions as to directions of travel and decisions and how we cope and deal with it.
Thank you, Minister. I'll pass on now to the Connotab.
Good morning, Mr. My area, this particular relates to public nuisances. If I may begin with, first question relates to environmental impact assessments. Can you confirm whether the EIAs submitted by applicants at the time of application to your department capture potential public nuisances, and whether you believe these assessments are robust enough?
I am struggling to get the connection between environmental impact assessments and nuisances. I don't know if you could you expand a bit further?
Okay, well, perhaps public nuisances come into the equation later. Can I concentrate on the EIAs to start with? Well, they are connected because EIAs will also cover noise, and noise is nuisance, and I think when you grant permissions, you do refer to such a nuisance.
Fire away and let my brain get into gear on this one.
Thank you, Constable, for the question. Environmental impact statements are part of the planning process.
Yep.
So only where planning permission is required would an environmental impact statement be required as well. Environmental impact statements will cover a range of impacts, and some of those impacts could be noise impacts or odour impacts in terms of how that impact would be negative or positive on the amenity of the area and the neighbours. Statutory nuisance is a separate law, and the thresholds for nuisance from a legal perspective are different to the thresholds for the impact on neighbours in a planning perspective. So whilst environmental impact assessments from a planning perspective will address the impact of items such as potentially noise or odour, it is a separate legal process to the thresholds that would be the tests under the statutory nuisance law.
Okay, I understand that. The general heading was public nuisance, and they qualify on both accounts, I think.
Yes.
Okay, but that's it. The theme behind my question is that where an EIA assessment is required, they are of course submitted by the applicant. Are you generally content that those assessments are, again, to use the word, robust enough, given that they are acting for their client?
I think Qtly Kevin might give us the answers, but certainly one thing about environmental impact assessments or statements is that they have to be compiled by people with specific qualifications. We've had a couple of cases recently where we've had discussions with applicants over the quality of EIAs, but it's very clear to us, and I think it's written down, that only a certain, you have to have qualifications to be able to write an EIA.
Correct, Minister, and also that statutory consultees will then objectively assess that EIA and contribute. So in the instances of nuisance, our nuisance officers would then assess and evaluate the environmental impact assessment on the planning side and provide their expert advice and guidance to the tests, essentially, for planning.
Okay, well, thanks for that clarification. Moving on to cases where EIs weren't required at the outset, can you explain what work is done with operations or established prior to the introduction of EIs to ensure that their impact has been assessed in line with current requirements? So where an EI wasn't required at the outset, I mean, is an ongoing monitoring to not quite backdate the procedures, but to enforce what should be in place?
I don't know, who knows the answer to how long EIAs have been
The
required?
EIA order is 2008, I believe, 2008. In terms of the distinction, if an EIA has not been required for planning permission, then it is not required. And so from the planning side of things, there is no further action. From the statutory nuisance side of things, we would actively monitor whether or not nuisance, as defined by the statutory nuisance law, would then meet at the point of threshold for us to take formal action under that law. So the active monitoring of nuisance, if it's not under the planning regime, would fall within the statutory nuisance.
Yes, and that is where the
And
link
that's
is to
where
start with. Yeah,
Correct.
okay. So again, on where EIA was not necessary at the outset, it comes within the possible realm of a statutory nuisance, and if it's referred to, you will take measures to ensure
Absolutely,
that.
and I think, nuisance is something which we get a lot of correspondence about, and one has to consider the severity, the type of nuisance, the frequency, and there's a lot of considerations that go into deciding whether genuine nuisance is there or not. But I think in many cases, the department are very sympathetic with the person who is claiming that there's a nuisance. In many cases, we're empathetic and understand that they are being affected. But I think I'm right in saying that the threshold, if you like, for nuisance is the effect on an average person. And I'm not saying for one minute that the people who are claiming nuisance are any different. But there will be cases where individuals get affected by a nuisance, which the average person may not get affected by. And those are quite challenging cases. There's case law in the UK about this, which is where we would refer to, not so much case law in Jersey, but there are some definitives here. I'm trying to think about what else there is, but we certainly accept the fact that individuals get affected by some things more than others. But when it comes to statutory nuisance, the law says if the effect on an average person is regular and severe enough and the frequency occurs often enough, then it would be classed. But we see a number of people who are quite clearly upset by something that's going on, and we empathise with them, but actually getting that to a statutory nuisance officially can be...
Have you... one part in seeing the overlap between environmental impact statements and public nuisances, of course, new development, and new development will cause new nuisances that are in part captured by statements. Have you reflected as a minister or department on the thresholds for creating environmental impact statements? Because, of course, within the law, they're prescribed often by their size, and many of them are 1,000 square metres, 10,000 square metres, but Jersey's context is quite different perhaps to many others. Have you considered whether the thresholds are appropriate, that in such a constrained island our developments would have to be incredibly large to trigger environmental impact statements?
Certainly. I mean, I can't say I've sat back and considered the proposals you're talking about. I mean, most recently one of the EIA that I've not nuisances, but an EIA concerns the foreshore, and there's some very specific requirements on the particular application, and if your application is covered by the tide on a regular basis and this type of stuff, it just automatically triggers. So that's a sort of a requirement that's triggered by something that's actually written down. But when it comes to nuisance, I take what you're saying on board, but it's not something we have thought about considering changing thresholds.
I think the Environmental Impact Order, as you know, is 2008, and I think it has been on a list for possible updating. It does not currently meet the EU directive for environmental impact statements. However, that has been a deprioritised action in favour of other elements for planning reform and water and food and other areas. I think it's really important to note that even when an EIA is not specifically required, planning will always assess the impact generally of noise and odour and other elements. So the environmental impact statement is a very specific order and requirement for large developments, but that is not to say that we wouldn't make those judgments anyway within the planning process.
But just to capture that, it's been identified that the existing order we have is considered almost a legislative gap, or kind of, there are perhaps better ways or more modern ways we've seen in other legislation like the EU that we are not currently kind of in step with, and we've had to deprioritise that, just so we're clear on where we are.
We could add that into a long list of things that we'd like to do if we had the time and the resource to do it, and it may well be that the next government will look at it, but I mean, my list of things we're going to try to achieve between now and next year is already squeezed completely tightly.
Okay. Yeah, moving on. Accepting that the EIA assessment aren't the be-all and end-all, and you have recourse to such a nuisance law, do you regard that law, the current law, as being fit for purpose regarding both regulation and penalising, possibly particularly industrial scale agricultural land?
Well, certainly industrial is an interesting word, Constable, and I'm aware that certainly when it comes to statutory nuisance, that is an area that we have thought about making modifications, construction sites specifically. And as the deputy's already hinted at, you give an approval, and quite often with that approval there may be some constraints on timing of construction and stuff like that. Not to say that there may be other things which aren't considered at the time which might well constitute nuisance, because I'm just trying to think about light pollution. Depending how late they go, there will be dust, there will be noise, there will be other types of issues.
Minister, we have considered nuisance specifically from construction sites, and that was also and an upgrade to the current statutory nuisances law, which is 1999. That has been again on a list for legislative change, but deprioritised again in favour for planning reform, water, food, and other changes.
And I think I'm right in saying that the other one of two that we had considered, the first one was construction, and the second one was the ability of individuals to bring actions themselves. I can remember that correctly.
Private law of voisinage.
Yeah.
Thank you.
So, in relation to my question, is there any current intention to update the current law in any way, whether for construction industry or agricultural industries?
I can't remember the last time voisinage was changed, but I am aware that it dates back to the 1700s. So it's not a new law.
We would like to add a civil provision into the statutory nuisance law that would act in a similar way without having to go through the voisinage process.
But
I shouldn't joke about it because it's a serious issue for some people. But there are aspects to it which are quite, been around a long time, and it may well be that we need to look at making it easier for individual islanders to take action.
But there's no change on the immediate horizon from your point of view?
No, all I can say is that both the construction sites and the individual's ability to bring actions are both under consideration, but not on the list at the moment.
A general point then, I think you already alluded to it. Do you receive more public nuisance complaints from certain industries rather than others?
That's a very good question. When it comes to industries, I think it's probably fair to say that the very new cannabis industry in greenhouses has given us a few challenges, and Constable, you'll be aware in your part of the island of one. And there are others. We were, as an island, warned about the smell and odour challenges from cannabis production sites, particularly in Canada, before we started. Hands up, if we could go back and start the medicinal cannabis in Jersey program again, we may have done it differently. But we are where we are, and we're attempting to deal with those challenges that industry puts to us from a nuisance perspective, and specifically smell is one, noise is another. But there will be other nuisances which would come from any greenhouse site which is being heavily used. I mean, that's just the way of the world. But when it comes to industries, there's always challenges from construction, which is why through the planning process we always seem to try to, if we can, put some restrictions on that. But no, I guess we could say that particular new industry, if you like, of growing cannabis in greenhouses has been a bit challenging.
Okay, I may have another question on that, but you've touched just now on both odour and noise. What criteria are used to assess whether a nuisance is occurring in each case?
Well, I'm going to look to Qtly here, but obviously we usually say to people who feel they are having a nuisance, the first thing we would advise them to do is to take a log, write down the frequency, the times of day that you're receiving this nuisance. We then might look to install some audio monitoring equipment so we can, if it's a noise issue, and we'll then look at the levels of severity. And we'll build up a picture of how often, how frequently, and when it occurs, how severe it is. And there must be a point. I know that there will be not a tick box exercise, but there will be a way of coming to the bottom of the page and saying yes. And Qtly will tell us a bit more about that, I hope.
That's correct, thanks, Minister. Officers, statutory nuisance officers are trained in assessing statutory nuisance. It is an objective assessment, and there's a master's qualification that you require to be able to judge nuisance. The impact is judged on frequency, duration, character, the severity, and the effect. We also have to have a very linked evidence of the source, which is incredibly important. And finally, it is about that reasonable objectiveness. So as the Minister mentioned before, the average person test. Within law, once an abatement notice is served and non-compliance with an abatement notice then could potentially lead to an offence. And for that to occur, there will also be a test of whether or not they had a reasonable means of defence. Essentially, if they had practical means that they've put mitigations in place that haven't quite met the threshold. So there are a lot of points of assessment and judgment in statutory nuisance legislation.
Yeah, I mean, I sense what you say that, I know from experience that you do inspect and you go at various times of the day because these things fluctuate in time.
That's correct. Our officers from the Housing and Nuisance team do early morning visits, late night visits, weekend visits, as they are not bound by sort of regular office hours. They do unannounced visits as well as scheduled visits.
And to answer the complaint by some neighbours, you don't give advance notice of these visits because there are some suggestions that they operate their outflow to meet the
combination.
visits.
We will have scheduled visits that are identified, but then we will have unscheduled visits.
Okay, and again with sound, that's relatively easy to monitor, where you can actually monitor it with
the department
decibels.
have monitoring equipment which is all checked and verified and is installed by officers inside the home or wherever the sound is required to be monitored. But I think the important thing that Qtly mentioned right at the start was that there are a number of different ways of coming to this calculation, but in every case, the officer that is in charge of it is heavily qualified. You know, it's not something that a junior officer that's only been employed for a few weeks could go out and assess. When it comes to the final determination, you know, the officer's in charge. A master's degree required, so that they are specialists in their field.
And there would be chartered environmental health officers.
Yes, and just before leaving this topic, I mean, I say sound is probably easier to monitor than smells. I'm aware that certain organisations do mitigate the smell by putting in devices, but you rely entirely on a smell test or sniff test, is that right?
Yes, I can answer that question. Currently, the only way to monitor smell is through the nose. There are machines that will be able to gather odour, but the gathering of the odour would be taken to a laboratory and there would be an assessor who would actually sniff what is in the machine that's gathered the odour. So at the moment, the only way to smell is via the nose, internationally. The sniff test or the smell, so officers are trained in terms of the unpleasantness, the severity, the strength of the smell. There is a chart, a range that an officer would go out and sort of mark at varying degrees of smell. So it is a trained science to make judgment over smell.
And of course, difficult when it's something subjective like smell. You know, it's only, as Qtly said, only the officer that is going to be in the position. He can't sort of suddenly plug in a machine and say, yes, smell level is 9 out of 10 and severity is what have you. So that's why it's really important that these officers are properly trained and have the right qualifications.
I would also potentially add that we would send multiple officers if there was any concern about judgment. So we would have multiple officers who would all independently and objectively assess, and we would calibrate those assessments as well.
Okay, moving quickly on from me, you mentioned medicinal cannabis, Minister, and suggested that perhaps, I know you're on the panel which looked into this and the regulations. You are inferring that we could have done better. Were those your words at the time of regulation, that if something had been in place at the outset, that might have avoided certain of the problems?
I think it's fair to say, Constable, both you and I sat on the same side of the table for that review, and we were critical in some areas. But I think one thing that we should maybe have thought of much more carefully at the time was the health department, if you like, and had responsibility for some things which now would be in the Environment and Regulation Department's remit. And I think it's fair to say that we should have looked a bit harder at smell, and there are things that can be done. I certainly didn't understand at the time that it's only a certain time in the growing cycle that smell is a serious issue. But of course, when you get to a particular size of production and you have various areas in your production site, if you like, at different stages of production, it may well be that smell almost becomes a continual issue. And then, of course, when it comes to nuisance, that regular frequency and duration of any type of nuisance then will make a change to whether it becomes a nuisance or not. But certainly taking smell out of the air that's leaving the greenhouse is something we've got to think really we've got to continue to work hard on for the future, for sure.
Sorry, Chair's looking at me.
Yeah, no, I was thinking for time maybe to ask 18, and then maybe we put the rented dwelling licence to the end scheme to the end of the.
Right, yes, sorry.
Your
Rented
last
dwelling.
question 18 is probably.
Oh, yes,
good.
fine.
Is
Yeah,
a
sorry, the
question.
last question I have,
Last
which
one.
really relates to applications generally, and the question of piecemeal applications, which I think can cause disruption. Do you consider they should be treated as a form of non-compliance under the planning law? If there's
Piecemeal applications.
applications in the same project, as it were?
I don't think there's any doubt that if you have a large scheme which will involve a number of different phases, that planning officers really appreciate a long-term overview of where a site is going over a period of time. And I'm thinking specifically about areas like there's Orme, for example, where I know I've had meetings and a long-term vision is put forward to officers where they can see how next year, the year after, and what have you, and it gives you an idea where you're going. The other challenge, of course, on the other foot is if you put in a large application which has a number of sections to it, and one particular section results in a rejection of everything else, applicants then feel, maybe what I should do here is put in multiple applications, so at least I've got 4 out of my 5 passed, and I can work on those while I decide to do what I'm going to do with the last section. So it swings and roundabouts with multiple applications, but I take on board the view that at the outset it's very much more beneficial to have a vision for where you're going, because what we wouldn't want to do would be to pass a number of smaller applications, which one leads to another, leads to another, and you get to the end and you think, had that single entity, which has been a result of all these applications, if that entity had been put forward as a single application at the beginning, would we have passed it? And that is always a challenge for officers to see where you're going. So when it comes to multiple applications, I can see both sides of the fence on that one.
Could I make a point, Minister, just in terms of this under the law, the department is not able to refuse the acceptance of the submission of multiple applications simply because they're multiple. If an applicant chose to submit multiple applications, we would have to take that on face value. There's nothing under law to say that we would be able to reject those applications simply because they're piecemeal.
I understand that, and I might come into the realm of tweaking the law to cater for that.
Yeah, and I think we move on to Deputy Curtis, who is
We've
going
got a
to
lot
go
of questions on the island plan and the planning law.
planning which
Feed him up.
fits
Nicely for the next hour.
And we'll continue straight off where the Connotab left, which is, of course, firstly, you'll be making changes to the law. Is anything from the previous section, the way that cumulative applications appear, piecemeal applications, something that you're lining up for changes within your next amendment?
Well, it hasn't been lined up. I can say that it hasn't been discussed officially, but I certainly know through discussions I've had with various people on the planning committee that in the past, probably more so than in the recent 12 months, but certain discussions have been had about how piecemeal applications can lead you to somewhere you don't necessarily want to go. And certainly it's something that I think we could discuss in the future, for sure.
And the other part you mentioned was about the risk of large applications with one objectionable element. Of course, the Minister has the power to approve applications in part or refuse in part following advice by the Inspector. Do you think that's a power that you're also exploring for a wider use to allow for wholesale master plan applications Is that within your plan for this amendment to change?
Well, it's certainly something that could be considered, and of course you're quite right. When I sometimes get to determine a recommendation from one of our independent inspectors, it may well be that conditions are added or removed, or certain parts are changed and whatever. Certain bits are approved and certain bits are rejected. And certainly on appeal, there's different grounds for appeal, as you will know, and some will fall away and some will be taken up. But yeah, it's one for discussion. Okay. I think it's certainly something I would value discussion on, but quite where it would lead us, I'm not quite sure how we would regulate for that.
Okay. So moving to the island plan and the bridging island plan, I think it's clear, Minister, you've said that we won't be getting a new island plan in your term. I think that's clear now. But will work have started within the next 12 months on the evidence base for a new island plan? And if so, how far will it get?
Well, I'm going to look to Kevin, but I think in very broad terms, we are continuing to do certain pieces of work which we know are going to be required for the next island plan. And I think for my priority listing specifically, I mean, where we go with water, how we are going to secure sustainable water supply for the next 20, 30 years is an important part of the work. But I know we've discussed only recently some of the other evidence that we will need before we come to a next island plan debate around population, for example, and that's something that I know we won't want to do until very much closer to the agreed date for the island plan, in as much as we will want the most up-to-date population figures and the most up-to-date population trends before we go into that island plan debate to rezone sites for more housing. And I think we only need to look back at what's happened in the last 7 or 8 years, where we went into an island plan debate knowing that the projections and the forecast for population were quite large. We zoned accordingly, expecting to have a new island plan debate probably next year. And we know that the demand for housing and the population has certainly plateaued, yep. which is the one and only reason, I guess, that we're in a position to be able to roll this bridging island plan down the road for another 2 or 3 years, because we know the housing provision, the rezoned sites are going to allow us to still cope with the demand. I don't know, any other evidence-based stuff that we're going to do between now and this time next year, Kevin, that's specific to island plan?
Well, I think, as the Minister's already referenced, the work on water has started. So I think in the last island plan review, there was evidence submitted by Jersey Water that highlighted the challenge that the island had in terms of ensuring a sort of robust and resilient water supply for the island. So that's something that the next plan will need to address. And as the Minister's already said, that work has started to look at what options there might be for ensuring a more robust and resilient water supply. So that specific work has started. I think perhaps the other point to make in general is that people view the island plan review as a one-off, as an entity. In fact, during the plan period, we try and monitor the efficiency and the effectiveness of planning policy. And we do that working with our colleagues in I&E regulation. So over that period of time, we are looking at how the plan is performing.
We'll be getting there.
Yeah. Okay. We'll be looking at those sorts of issues as well, looking at what policy changes might need to be made in the subsequent plan.
I think we'll get there. We've got a lot of questions, so I think if it's about also evaluating what's working, what's not, we are definitely touching on that. But I know Deputy.
No, that's okay. I was going to leave it if that's
okay.
Yeah.
I probably may stay.
We'll try to speed up with our answers,
and I'll try and speed up with my questions. You've mentioned as well on the plan that you might consider different forms of the plan. How's your thinking evolving on the structural form of an island plan? Noting, of course, its current form is prescribed in law.
Yep. We have committed to having a look at different ways of island plans, if you like, or plans. And I'm aware that in France and Australia, they've got certainly different ways of approaching this. I can't say that any of those approaches lead me to a conclusion initially that the system we've got needs changing. I'm very much of the view that if you not broken, don't fix it. Having said that, one of the things, very briefly, we are going to do as part of the Planning Before programme is this summer we're looking at a number of things to go out to consultation on, and one of those I want to definitely do, if I can, is to go back to the way we were previously before the Bridging Island Plan. You'll remember we changed the law so that we could do things in the way we did them. But I think it's important that individual policies within the plan need to be able to be changed within that plan timing. And that, I think, is really important, because who knows what might happen in a 10-year plan period, whether that's population, whether there's all sorts of other things, and it may well be that we need to make some changes, big fundamental changes to an island plan in mid-term. And so one of the changes we're looking to do as part of planning reform will be that.
Is that a power you would like to see within the Bridging Island Plan? So before a new plan emerges, you would see a minister be able to propose changes to the 2022 to 2025 Bridging Island Plan, or is it purely that when a 2027 or 2028 or 2029 Island Plan appears, that power is resumed? I
think if we do the consultation and if we come to the conclusion that that change needs to be made, I personally would look to make the change as soon as possible. And I would say it won't matter whether we're still in the last throes of this current Bridging Island Plan or at the first few years of the next Island Plan or into the middle of the next. If the principle is that we want to be able to change and we have a proper reason to make a change, let's have that debate.
Okay. Looking to the Island Plan and future needs, can you detail what relationship there is, if any, between Project Breakwater and a future Island Plan?
Well, Project Breakwater is something that's still to come out of the Council of Ministers in a final format. I'm aware that there's some discussions, as we all know, going on about Fort Regent, and it may well be that it's referenced in the Island Plan, and I think specifically it would probably be to do with Fort Regent, as you say. We know that structures up there are fairly heavily listed. And similarly, there will, I don't think, be any doubt that there will be some discussion and challenge around replacing a new or putting a new structure where the swimming pool used to be. Planning is very clear. If you have an application to demolish and rebuild, that's very different from an application to demolish and 6 months later, 12 months later, 18 months later to rebuild, because it's not rebuilding, it is a new building at that point. And look, the policy is very clear on that. Once the site is empty, it is empty.
And of course, the site there was cleared without a replacement structure on it, is what you're suggesting, Minister? If I remember the application, it was.
I don't believe that application to demolish the old swimming pool came along with a pre-approval for build whatever the island might wish to put there in its place. Having said that, I do think some of the ideas for the redevelopment of Fort Regent are very exciting and look very good to me. Like everything else, it will come with a price tag, and somebody will have to find a way of paying for it, and that will be another challenge.
There haven't been really wider conversations beyond Fort Regent, and obviously there will be planning challenges that there's a wider intermingle between whatever Project Breakwater will appear to be and a future Island Plan. There's no whole scale.
I've indicated recently that I want officers, and we've spoken about it again this week, we really need to have more input on applications that are going to impact heavily on the economy of the island, and Fort Regent might be one of those. But notwithstanding that, as Fort Regent's heavily listed inside and out, and doing works planning wise will be challenging.
We'll jump straight to the economy. This is something you've mentioned multiple times, Minister. What does taking a focus to kind of giving more weight to economic matters mean? Is it about really thinking about employment uses? Is it about short-term economic changes like development, or is it really about enabling the future economy through land use? And how do you do
there's
that?
a number of issues to the economy piece. You mentioned one right at the end, the short-term development bit, and I'm very conscious the construction industry generally is going through some challenging times. We've seen that through the demise of a number of established construction companies, and that on its own is important, that we want to make sure there's enough development for those employed in that particular industry to keep working. That's really important. But for me, I also want to look at the other mainstays of the island, particularly tourism. I'm absolutely conscious of the really big link between connectivity on and off the island and the tourism industry. I mean, the public of the island benefit from lots of planes going backwards and forwards. The business sector, financial services sector benefit from that connectivity, but a lot of that historically is driven by tourism, people flying in and out for holidays, and we lose one of those legs to the stool, if you like, at our peril. And I'm really conscious that I'd like to see, where possible, the development of new hotels. I think our offering to tourists has changed over the years. No longer do they come for 2 or 3 weeks. It's now short breaks. And we need to offer more in that regard. But I think getting back to the fundamentals, I am very conscious of the number of beds, that our bed numbers in Jersey for the tourist industry have dropped now year on year for a long time, and it's time we address that.
Are you concerned that obviously the current island plan, as with the last, provides no protection for visitor economy beds? And whilst you acknowledge changing appetite, the plan provides no protection, even for our best loved hotels that are some of the jewels in the crown. There is no protection for those. Specifically, there may be policy routes to protect them, but they'd be harder to find than any other employment land, bar, office accommodation.
It's a really another challenging discussion that I know has been had over the years, whether a restriction should be put on hotels that they can only ever be used for hotels in the future, and that's the end of it. Obviously, there's precedent here, a number of precedents in recent years where hotels have been demolished and housing has been rebuilt. That in itself has led to a reduction in bed numbers. We haven't had that many new hotels on the island of late. But I'm also conscious that the value of a site needs to be a value, and that by a potential housing value, I'm not saying a housing value, but a potential housing value is at a level which helps hoteliers, balance their books. So, I mean, it's a really difficult. I don't want to stipulate to anybody that their hotel has to stay a hotel forever. I'd be much happier for them to say we're really happy to have a hotel here because it's full of people all the time. They come to Jersey, they have a great holiday, and our demand looking down the line is where we're very happily booked.
Do you feel the same for light industrial? Do you feel the same for retail, that the owner of those sites should likewise have that planning right to remove it from an employment use?
Well,
that's kind of how you've said it. You said, I don't want to restrict them, but we restrict every other industry.
There's always conversations to be had, and we see a number of applications for changes of use during the course of any year when the department. Some are quite big applications for change of use, and I guess everyone has to be judged on its merits. But certainly when it comes to light industrial, certainly my own personal view is that over the decades that we haven't allowed enough sites for light industrial, and it's always an ongoing challenge trying to find places for people to operate out of.
Okay, you see,
Come in,
yes.
with respect in terms of the hotel question, if you go back to an amendment to the island plan that I brought regarding hotels in St Paul's Bay, which was rejected, and it was rejected by on the weight of owners' opinion, actually, not wishing their business to be restricted. So maybe worth looking back at that.
I remember watching that one, and it's just an interesting question, Minister, that you're keen to support the economy, but our policies still are two-tiered, and one of the most important areas you want to support, the visitor economy, has the least protections to guarantee a sustainable future.
Well, it has been discussed in the past, and I'm sure it will be discussed in the future as well. But as the Constable said, I think one part of the discussion, very much so, has to be the owners of these properties, and they've indicated to us thus far that they don't specifically want a restriction on their hotel to be a hotel forever.
I just wonder, I think this was an issue that was brought for debate with the inspector, with the examination in public of the Bridging Island plan, and I wonder if Kevin would be able to provide a little bit of information on that.
I think we've probably gone round the minister's views on this. We could spend this. We could spend.
I'm sure it'll be an issue that will be debated at the next
Okay,
island plan review.
brilliant. We'll move out of the island plan into planning reform because we have to keep moving. And so, Minister, please can you confirm which targets from the Planning Services Focus document are still outstanding?
Jeepers. Sorry, did I say that? Kelly, can you help me here? Planning Services Focus document.
I think we were successful at completing all of the short-term focus. In terms of the medium-term focus, I think the one that is left is the implementation of the reader system. And the long-term focus is also obviously around the changes to permitted development rights, the island plan process and the appeals process, which is part of the reform consultation from summer onwards this year. So I think those are the key elements. What we have seen is very, very successful implementation of performance measures within the planning team, case review meetings, and making sure that applications are determined, and in the last 2 months, 90% in target.
Okay.
We've had some really good stats lately. You'll be aware that Jim McKinnon's coming back next week. That's going to be the third time he's come to visit us. I did have a chat with myself about whether we asked him to come back again, but I think the department have done great work, and I'm really keen for Jim to come back and verify that from an independent perspective and tell us how much improvement we've made. Can I just add, Industry Partnership Board is something which to me stands out in the work we've done in the last 12 months. That's a board of people made up of developers, architects, etc., who meet with officers on a regular basis to talk about challenges and where we can make improvements. And I think in nearly every case, people are really positive about that.
We've got 2 places to go out of that. One is the Industry Partnership Board. Are you happy with the representation on it? Does it have, a diverse enough representation of island interests?
I don't know that it has a diverse representation of island interest, but certainly it has a good representation of people within the construction industry, architects, developers, that type of thing. And for me, we have got 1 or 2 people on there who've been quite challenging over the years. And the best bit for me, if you like, is that they are coming to me now and saying we're enjoying the work we're doing, we feel we're making a contribution, and we're really pleased with the progress we've made.
Minister, I think just focusing on that a bit more, obviously the Bridging Island plan is diverse enough. It also has that elements of the environment that we've been talking about in the past, and merit heritage, other things that the islanders would like to focus on. Do you think that this board should have more wider representation? For example, are the National Trust involved, or Jersey Heritage, that can bring that other angles to it that are covered in the Bridging Island plan, but maybe not be represented in those stakeholders you've mentioned?
Well, the first thing to say is I meet with people like the National Trust as often as I can, certainly the new CEOs. We've had a number of chats, and I'd like to think that maybe we work with them in a different area, if you like. The Industry Partnership Board was formed very much to try to understand from people who use the planning process on a regular basis the challenges they face, how we can work together to make things better for both sides. And I think from that perspective is why we didn't have. We do have some representation from the countryside. I'm trying to think one particular person I can think of is
There were a lot of there were a lot of requests for membership to the Industry Partnership Board, which was obviously excellent. We have a rotational basis, so I think it's an annual rotation with an option to extend. So there will be the opportunity for a changeover of membership, and also that the Minister is looking to publish the Industry Partnership Board's first annual report on the first anniversary, which would be in May.
So that'll be are those decisions as to new members from May onwards happening now? Is there sufficient time for those listening to get involved and to try and be part of the 2025-6 Industry Partnership Board?
Yes.
Brilliant. I'm hoping people find that. Very quickly, and I'm sure the chair will cut us off this section when we have to move on. But you also mentioned the general development order or permitted development rights and other changes within the reform review. Starting with the legislative changes, could you identify the key legislative changes you are considering as part of the planning reform?
Well, GDO, I guess, is legislative change, and we will be going out to consultation quite soon. I suspect we'll have a large number of things that people will suggest to us would be a good idea to put into permitted development. But I'm really conscious that we need to always think really carefully before we make too many changes to GDO, in as much as there's always consequences from permitting people to do things, and we need to just be really careful how we do that. Other legislative changes, I'm just trying to think, appeals process could be very much a legislative change.
What could change there?
Well, we've identified recently in two instances that I can think of where, let me start again. 10 years ago, we changed the appeal system when I was Minister previously, and we brought in a whole new structure so people could find appeals, appeal more easily, and most importantly, less expensively, because at that point it was only the Royal Court and we were talking tens of thousands of pounds. Notwithstanding that, we've recently identified a couple of areas where, for whatever reason, appeal wasn't put into the legislation. I think in one in particular, mobile structures order
Yes.
didn't have an appeal put into that. And also similarly, one I think that's just come to my attention recently, which I need to investigate, is enforcement. I think there's some sections in the enforcement where there may not be an appeal, so we need to look at those. And in the wider scope, we need to look at whether we want to broaden the ability to appeal, reduce the ability to appeal. And of course, it's one of those two-edged swords. Depending which side of the fence you're on, do you want, you will want the ability to appeal against something which you're upset by. Similarly, if you're the person making the application, what you would prefer is to have less people with the ability to appeal against your application. So again, it's something that we need to look at and balance and see where we go.
And you mentioned you're going to go to consult on the development orders and permitted development. Do you think the public and the industry understand the scope that one can reasonably change? And I note that the law says that a development order cannot grant permission that's inconsistent with the island plan. So it can't change policy at all. It can't do anything that the island plan would not allow. Do you think when you consult that's understood by enough people?
I think the art there is in the art of how we phrase the consultation, and we don't want to lead people down a particular path, but I think it's incumbent upon us to put out a wide range of things that people might want to think about and give them some examples. I don't know, Kevin, you want to talk a little bit more about that quickly?
Yeah, I mean, I think, as the Minister said, the scope of this work is still in train, but and we've yet to design the consultation, but I suspect it will probably comprise a mix of some specific proposals. So there'll be some preamble and then some specified change, which we'll ask people's views about. There might be some open questions on areas of possible change, and then there might be an open comments box. So, hopefully that will provide people with sufficient focus, but also flexibility to come forward with issues of concern to them, but also to give their views on specific proposals that the Minister's looking to make.
Okay, great. And lastly, I think for me, I'll have to wrap up. The building bylaws, how's the review going on that? What's the timeline?
Well, I think Kelly will probably give us the timeline, but work is progressing. The thing that we do have to be cognizant of is that we're not led in the UK, but I think it's quite important that we stay fairly consistent with what the UK are doing, because there will not be any point in us coming up with very specific insulation requirements which are greater than the UK, and then expect manufacturers to come out and produce stuff specifically just because Jersey has taken a new view. But we're getting there.
I can add to the Minister's points of the work stream for the bylaws review. Of the 12 technical guidance documents, we have divided that into 3 main work streams. So focusing on safety, which is the TGDs of 1, 2, 4 and 12, a second work stream of net zero, which is the TDGs of 3, 5, 6 and 11, and then the accessibility and home standards, which is TGDs 7, 8, 9 and 10. So at the moment, we're doing a high-level review about sort of best practice currently, where potential changes could be. And in terms of the timeline, we're still looking at relevant stakeholder engagement starting from spring.
And to what extent are you going to be evaluating the impact on build cost that any change to the bylaws will have? Do you think there's any scope that it will help lower build costs, or do you think every activity or action you will review will ultimately lead to an increase?
Well, again, this is another one of those balancing acts, and one has to decide whether the build cost and the initial front, the payment up front is the important factor, and whether one's better off to pay a little bit more at the front for a property which is going to take a lot less money financially to heat and to run, and whether, for example, I mean, people criticise me in many ways, but one is, why don't I stipulate that every affordable house we build from now has solar panels on the roof? And I can see a case for doing that, and I can also see a case for saying, how much more do I want to add to the cost of that initial home? And we know that the cost, at the moment is a real challenge for people. So it's a balancing act, but we do need to stay conscious of how much these properties take to build. Although from our perspective, from building, from net zero, from carbon, we need to try to make it easier for people in the future so that these homes require almost zero energy in order for people to stay warm.
Thank you, Minister. And just lastly on that, because, saying that you're going out to consultation in the spring.
This is targeted engagement with stakeholders.
And where do we see the changes to the bylaws? Would they be coming to the States Assembly?
I don't know that they do. I think I do.
It would depend on the range of the changes. So if, at the moment, we're just doing a gap analysis of where we might make changes. Some may be in the guidance, some may in the bylaws themselves, some might be in primary legislation. But until we've gone out with that sort of gap analysis and proposed changes to industry and to stakeholders, then we'll be able to see whether we're looking at guidance which wouldn't be assembly based, but if it was bylaws themselves.
I think I just need to stress again, this is not like an island plan review where we're looking at every policy within the bylaws. That Qtly mentioned those 3 sections, and that's where we're sticking, just doing that on its own. But this is a technical review, and rather than a big wholesale appraisal of the whole way we do things.
I would agree with the Minister. There are some technical changes that we wouldn't consult on because there would be sort of no change based on consultation to the technical side of things. Say, for example, fire regulations or things like that, where there is the ability for the technical guidance to be adapted and amended based off comments and consultations and input, then those are the ones that we will be getting stakeholder engagement on.
I think where I was trying to get to is more, if this would still be able to be finalised before the end of your term. In that sense, it's been sitting there for a while. So
I very much hope so. I mean, as Qtly said, some of the stuff is sort of, I don't like to use the term non-negotiable, but when it comes to safety in homes, that needs to be as it is. And if we have to upgrade those bylaws on that, well, we will do so. But there will be other areas where we can have discussions, but it's important that those discussions are with developers and contractors, builders, so that they understand and we understand their challenges with what we're trying to propose, and we'll have a chat and come to a conclusion.
thank you. And going from land to sea, and to Deputy War.
Right, sure. So, sea, marine spatial plan, favourite topic. Please can you confirm the timeframe for designation of confirmed new MPAs? So what's the date of the publication? What will be included in them? And what is the timeline for those areas needing further research?
Okay, 2 dates I think which are important. The first one is May, and that is at the point we will publish a plan that shows what we're doing and when we're going to do it. So this is what's happening. And by the end of the year, we will have researched the areas which were designated for further work, and I will at that point be thinking about how I move forward with marine protected areas. But we will, around that time, move to a much greater area of protection for the island that we currently have. But there are, as we know, areas which are being researched more widely, and we are also going to research even further than we indicated in the Marine Spatial Plan debate. There's been some suggestions.
Do you mean by area or by
area?
Density? Okay.
So there's been suggested to us that there are some areas of the seabed where there may be merle present in quite large volumes, which we hadn't thought about before. And officers and the team are going to do research there as well. So there may well be some tweaks and changes. There are a number of different stages, if you like. There's some areas which are going to receive protection. That's not negotiable. We are grandfathering some areas at the moment. We're proposing to for certain people who've got a living to draw out of that. We're going to give them another few years to see what they want to do. And then there's these research areas where we need to, I need to understand more why a particularly large area is all down for protection, where some parts of that may have nothing to protect, and I need to understand that better. But we are going to go from single digit percent, or 5 or 6% we have protected officially, to somewhere around the mid-20s very quickly, and then there's other areas that we need to consider further than that.
So you can see this as going into the next government an issue which is going to be. You don't see this as being concluded in your time in office.
Well, the Marine Spatial Plan itself is a living document which will be modified. It will change and evolve with time. Marine protected areas will continue to change because, as I've said before, I think there's certainly some areas which have been grandfathered, and that's going to mean pushing that to the exclusions on those particularly small areas out to sort of 29, 2030 maybe. And while 30 by 30 has never been something which was registered on my radar, I am very conscious that 2030 is an important date for all sorts of reasons environmentally. Excuse me. And it's a date by which I would wish to have concluded all the variations and changes and movements, so that by the time we do get there, we know exactly where we are.
Okay, great, thank you. So skip the next one. So impact. So economic impact. Are you in a position to provide a timeline for delivery of the full economic impact assessment following the framework delivery?
We're continuing to work on the economic impact. I think that's probably about as much as I can say about that at this time. I probably need some advice, but we have sought information from the industry. They continue to feed back to us about the economic impact of some of the stuff we're doing. We continue to have that discussion, and yes, I accept that some areas are going to be closed off from dredging, but that in itself there are other benefits to closing areas to the dredgers.
Sure. Okay, so we skip Ramsar and we're going to fishing. Okay, so Minister, the panel recently met the Fishermen's Mission and heard the views of local fishermen and the struggles faced by the industry. What work is underway on improving the difficult industry conditions for local fishermen, and also what reports, if any, have you had on the status of local octopuses, interestingly, and what do you currently understand the impact to be on fishermen's livelihoods?
Okay, so there's no doubt that fishing remains a really challenging industry to be in. Over the decades, we've seen a move more recently to sort of more boats working single-handed, and that just reflects the difficulties in paying staff. But when it comes, climate change is affecting the species in our water. We've seen the brown crab specifically have moved away in great numbers into the North Sea and further up the North Sea. So we've got less of that particular species to catch. Lobster, equally, the amount of lobster in the sea at the moment is significantly less than it was 5 or 6 years ago. We need to understand this fluctuation better to cope with it. If it does come back again, I think we will need to find better ways of safeguarding that. But you talk specifically about octopus, and there's no doubt that, you know, the reports that we're getting from fishermen, not just here, but in Guernsey and other areas of the southwest coast, you know, octopus are coming back in great numbers. Some fishermen are finding ways around that to avoid the octopus eating lobsters in the lobster pots, because they, you know, they get into the lobster pot, there's a lobster in there, the octopus will go in, it strips everything useful out, kills the lobster, and then disappears off and moves to the next pot. They're very intelligent creatures from that perspective, but there are ways to deal with them, and at the moment we're looking at all the options. But certainly there are ways to fish for lobster and crab with octopus around. But I think I need to, you know, just carrying on doing things like you've always done them may not be the way to get over the octopus challenge, if you like.
So this next question says, can you provide an update on fishing activity as a result of the Sea Fisheries TCA to date?
Well, an update as regards the TECA. Well, we can just go back. We had a protracted negotiation with the French fishermen as to how many licences we issued. At the end of the day, the bar was set quite very low, in fact, and we ended up issuing 130, 140 odd licences to French fish in Jersey territorial waters, which is quite a lot more than we thought we would have to issue at the start. Since that time, we continue to work with the French fishermen, very much on a local and neighbourly basis. We get on really well.
Can I just dig into that number?
The challenges that come from the TECA and from Brexit are more difficult to challenge.
Just to dig into that number, why is that number so big for the French licensing? What's driven that? What surprised you about that? Because obviously that puts a tension, presumably, with our own fishing.
To the Granville Bay Agreement days, there was hundreds and hundreds of French boats who applied initially and were given licences.
Yes, so if I can come in, I mean, it came from the French side, and I don't think we had any alternative but to accept the numbers that were being proposed. And then at a certain point there was a cut-off, and you can refer back to the previous panel's involvement with that. Realistically now, the relationships between us and the French on the Normandy coast specifically and the Brittany coast are good. And we are focusing on the same areas. I think one of the areas of contention at the moment is the establishment of the border inspection post, the BIP in Granville, which they're very keen on, we're very keen on, but it's sitting on someone's desk in Paris, and that seems to be the glitch at the moment. So we've got this ridiculous situation whereby we have to negotiate with the UK, with London, they negotiate with Brussels, Brussels negotiates with Paris, and then it eventually arrives on the Normandy coast, and it doesn't get there. And that's where we are at the moment.
Yeah, I mean, we started off with, in the Granville Bay days, 700 odd French fishermen with a permit licence to fish in our waters, and very, very many of those never came anywhere near us. They were just given a licence at the start. And what we were trying to do is to get down to a point where the people who had permits and licences were those who actually make a living from fishing in our waters. But the way we did that was to say, right, you need to show us your track record, prove to us that you fish in our waters, and we will, if you do that sufficiently and it's sufficiently important to you, we'll give you a licence. And the bar, we reduced the bar on a number of occasions to make it easier for French fishermen to achieve permits. Department worked really hard, but we're down to 140, 135.
I think it's fair to say that a lot of French fishermen don't want too many of their compatriots fishing the same patch either.
I guess they're coming on. Yes, sure. So have there been any recorded breaches of the licensing scheme to date, by the way? So have enforcement powers been exercised in the scheme, and any redress action working? Is the redress acting as intended? And if not, what work is being undertaken to address this?
Well, the team have got, we've got three boats actually, means of going to sea. We've got the Norman Lebrock, which has on board a smaller rib, which can be used for then boarding fishermen, and we have a separate rib, which goes out very quickly. And I can say that regularly we are boarding boats all the time, and I wouldn't say regularly, but we've certainly got 2 cases on the go at the moment of fishermen who are being taken to court. I think I'm right in remembering it's 2, and usually it's to do with undersize. It's to do with having undersize.
I do think if there are potential cases, that the individual circumstances are confidential.
Okay. I'll say no more other than we board boats, and if there's any infractions, we take action.
Sure. Okay, so Minister, so do you want to go back
Well,
on this?
maybe just have obviously there's part of the TCA agreements was for 2026 to be a review, especially around fishing and energy. And as obviously 2026 is very close. So what kind of discussions are being had with the UK, Brussels, Paris, all the connected stakeholders, and in that, and what do you anticipate the department doing in this regard?
Okay, I may have my information wrong, but I'm not aware that fishing was part of the renegotiation, the reset of Brexit in 2026, and I would be very surprised if it was, because we're still trying to get over, we're still trying to get to the final stages of making sure we can get the original Brexit agreement satisfied, and there's some issues around licences and licence fees and charges and access. But as the Constable said, we are working really closely with the French on some of our management, and certainly increasing the size of lobsters and other measures like that. We're working really well with them, increasing the rings. So the local fishermen are going to benefit from a scheme to change the size of the rings they have on their dredges that they use for scallops. So we're going to move the scallop size up. Again, that will help, help the environment, the fishermen all round. But we talk regularly with the UK DEFRA and through them to Brussels and all the way around. But when it comes to fishing, I don't believe that that's part of the Brexit reset. The other one is, you mentioned energy. And of course, energy is something we are talking to the French about quite a lot. We'll go, the wind farm is a big project for us. So that on its own is a big piece of work, and we're aware that Normandy and Brittany have both got big aspirations for offshore wind, and we're talking to them about how we can work with them, or how that we might be part of their plan. Access into France for wind farm energy is a challenge the French are having to face, and certainly if they build wind farms to the west of the island, as they intend to do, they're looking at 2035 before they will have the cabling infrastructure on land to be able to receive that with that energy and then distribute it around their grid. So there's a number of moving parts on energy, and of course we're not that far away from another form, same form of energy but coming from a different source. I'm aware that we're not very far away from renegotiating with the Jersey Electricity with the French for the next power agreement for a number of years. So
yes, I think there's lots of things, and it's interesting to be sitting within these discussions, that there is at the same time this review that is happening between the UK and the EU around certain areas of the TCA, and how Jersey will be impacted is also very important. But
I'll go with the marine loans. The panel notes that the Minister for Sustainable Economic Development has launched a marine loan scheme. So what influence, if any, do you have on that decision process? And B, how do you expect or intend for the scheme to affect Jersey's marine sustainability practices?
Okay. When it comes to fishing, the Marine Resources Department sit within my department, and they do fantastic work, especially species management, licensing, all the research. But the economic side of fishing, the marketing, if you like, the landing in France, developing your exports, whether that's north or south, sits very much in the economy department, as does the money for any the fishing equivalent of the Rural Support Scheme, Marine Support Scheme, which has recently been introduced. You know, our fishermen are really proud guys, and for very many decades they've taken no help from government at all. It's only quite recently that they've been included in schemes or wanted to be included in schemes. But there are a number of areas now where we can help them, and we do everything we can to help them. I'm going to say regulation, but certainly they are required to do a number of things on an annual basis now, which they would never have had to do in the past. They all cost money. You know, fire prevention, first aid, all this type of thing. Their crew and the skippers need to attend courses to make sure that they're up to speed on all these type of, and that's more about you know, just making sure you're keeping your fleet as safe as you can. But yeah, there are ways now to inject more money into the fishing industry. I'm thinking specifically about this. Another one might be the fact that obviously the minimum wages are going to increase significantly in April. That will impact on the fleet. They have been able to access through the extra money that we've got through for rural schemes. They can access that as well. So there will be some help with them transitioning to the minimum and the increased living wage.
Thank you, Minister. I think we'll move on quickly to maybe a shortened version of the Qtly of the animal welfare.
Yes, particularly dogs, yes. On that general question, the dogs law requires the licensing of dogs and has provision for stray dogs, but not much else. Most of the provisions related to conduct of dogs and control them is enshrined in a code. Do you have views on translating that code into actual law?
Well, we are going to try to do better in the future. Where the instructions I've signed very recently, and I've brought the paper with me to try to remember a little bit more specifically what I've done, but I've got, I think we're on draft 7 or 8 now. It's gone back to law drafters to talk about animal welfare, dog licensing and dangerous breeds, and we're addressing issues such as tail docking in dogs, claw pulling in cats, so that animals imported can't have had that done to them. We're talking about mutilations, you know, ears and things like that, activities which are done to animals. We want to be much hotter on that. We're introducing sort of licenses for people who keep animals commercially. Not, I might add, the dairy. Anybody who supplies milk to Jersey Dairy will be exempt from this because they come under another. But there's a number of things that we need to go there. We're banning the export of animals for slaughter or fattening. That's something that's come through the UK. But again, we've negotiated a sort of a get out there for the dairy farmers who are growing beef cattle to a certain size and then sending them to specific markets in the UK. So we've worked our way through that one. And the other one is microchipping cats and dogs, which is going to become mandatory. And I think there's a number of good reasons why that's something that we need to do, follow the UK, and I'm trying to think what else there might be. I've got it here.
That's probably enough for that.
We are,
Sorry, I don't mean that rudely.
I'm going to make some.
No, I think, would that mean if you're chipping, making it mandatory, that then kind of like the dog licensing scheme would become kind of, wouldn't need necessarily a dog licensing scheme because you're automatically, when you chip a dog, you automatically are on a system.
No, I think it's important, and the Constable will talk to this, I think it's important we maintain the licensing scheme so that we have some control over the dangerous breeds.
Well, there is that, and the committee are discussing utilising the scheme in such a way that we can progress better controls on dog poo by using DNA. And that would be linked to a chipping system which might come in at the initial registration, and work is ongoing with that. But in terms of the dangerous breeds, we have types of dogs, the Dogo Argentina, the Fila Brasileiro, the Brazilian Mastiff, Japanese Tosa type dog, the Pit Bull Terriers, or the XL Bully type dogs to consider, that's going to be added at the start of this year once this law comes out. So
that you intend to ban those will be banned.
yeah, which I think is important.
Yeah, just trying to bring those points together. So where are we in the terms of draft legislation? Then?
Well, as I said, I think we're on draft 8, is it, at the moment? We're getting quite close to being in a position. I would hope to have this in the Assembly, certainly this year. I'd like to think it might be more around the summer. Something I didn't mention, welfare, general welfare standards of farmed animals. There will be some requirements there, and very specifically also some new welfare standards for dog owners. So some requirements on dog owners to look after their dogs, to a better standard.
Okay, thank you. I mean, sorry, given that you are there, you said being to Assembly, presumably Scrutiny will have the benefit of it before.
Yes, absolutely. I will make sure, in fact,
yes.
I can get this.
My basic point is that the control of dogs is largely in the code of conduct, and one needs the scope to translate that or transpose that to the law. That's something to consider when you're moving forward.
I mean, dogs law, welfare law are separate pieces of legislation, but I accept what you're saying. We need to keep them both, working in.
Okay, and then the other thing is on dog walkers. Sorry, dog walkers, as professional dog walkers, as it were. That there have been complaints about the number of dogs they exercise.
I mulled over this one on a number of occasions, and it is quite difficult at times to think how one legislates for a professional dog walker who's got 4 dogs, and a member of the public that opens the back of their car and 6 or 7 appear and run into. How one balances that, I don't know, but I think certainly some basic requirements on professional dog walkers is a.
Those requirements would include indemnity insurance, special insurance, presumably, or is that for the economic?
I'm not sure. I mean, I'm looking at my assistant minister. Would that come under dogs law? In which case, it would be Qtly?
I think it would be, truthfully, and I think that there is work to be done, because clearly is an unsatisfactory situation prevailing at the moment. But I think that's.
We have there's a code of conduct for dog walkers, but I take your point. There's nothing in legislation about the number of dogs that can be.
The code of conduct is well set out, I think.
Yes,
if you could pinch some of those words, put them into law, that would be helpful.
Yeah. With all these things, it's policing it in the right sort of way is the challenging part.
Yeah. Okay, I'll move on. That's right.
Thank you, Qtly. And I think just for the last 15 or 20 minutes, because we were started a bit late, I was wondering maybe, Qtly, if you want to carry on with your agricultural lands questions, specifically 71 to 70.
Yes, okay, yeah. Yes, privately I raised a couple of points with you, Minister, on the law. It's a 1974 law, requires your consent before agricultural land can be sold or leased out. And the concern I have is as to whether you're exercising that decision as Minister, because the law refers to good husbandry, and how does that interact with your duties as planning minister?
Yeah, I'm trying to re-engage my brain on this issue, but my recollection is that I've had some information back very recently, which I need to convey to you, Constable, because you have inquired, and I will pass that on. But I think I'm right in saying that there's 2 things at play here, and the law that says I can grant permission for ownership and change of ownership is separate from the other piece of legislation. And the 2 don't necessarily need to go in. So you get a planning application for something in an agricultural field or what have you, or you have the permission of the owner. But that doesn't necessarily need to tie directly to the other piece of legislation about my consent for change of ownership. Have I got that right?
That is correct, Minister.
Yeah.
So the 2 laws operate independently. Conditions applied under the agricultural land would not be a reason to refuse or necessarily approve under planning permission.
So the minister acts
would be
independently, deciding whether to transfer land. Yeah.
Yes, I have to say that that's one of the very many delegated powers that I give to officers, and I have people in Kelly's team who make that decision on my behalf. and unless things are highlighted to me differently, that's the way it has. Well, that's the way it works.
Okay, and the final question I have on this is that, given the two are separate, as it were, it occurs to me if you were to refuse your consent to a transfer of land, yet a planning application has been made on the basis that the transfer would take place, a lot of time could be wasted if your consent was not forthcoming first.
I mean, as you will know, an application is approved or rejected, but if it's approved, it does not mean it doesn't allow. It doesn't allow any successful applicant to go off and do things which would be contrary to other laws. So
Yes, I could add, Minister, the planning permission is purely permissive, so it doesn't override any other law.
No, my question was really as to whether, to avoid unnecessary work done on a planning application, the consent could be given in advance independently.
Similarly to a question that was answered earlier in this session, there isn't the ability under law for us to reject a planning application. When it is submitted, we have a duty to determine that application. So by virtue of the fact that there is a decision made under agricultural land law would not be a reason not to accept an application by planning permission. It's up to the applicant who wants to submit that application.
but I take your point. There's a chicken and an egg situation here, that if a change of ownership may well happen, but the new owner may want to know that he's going to get a change of use or an application passed. Similarly, if you looked at it the other way,
And
Could I just ask on? Because they are separate powers under the law, and there are many things you could do with planning and not obviously enact your permission, like failing to meet building control. But within agricultural land, have you spoken with farmers as to whether the law is working? So, especially, I think to the conversations I've had with the dairy industry, who are losing the right land, and it's your power, Minister, to choose good land management. Are you thinking as to whether the policies are being used?
There are some challenges, and I have discussed them with officers recently, not necessarily all the officers in my department, also officers in the economic department. And it's quite clear that governments don't have a handle on what's going on in as much of the agricultural land as we might have enjoyed in the past. And certainly I think we need to have a discussion with the industry and with landowners as to how we access better information, so that, I'm sure that 20 or 30 years ago you would have said to me, can you tell me about specific field A, B, this field here, and the information would be in the department available for me to see. I couldn't put my hand on heart and say that I could get easy access to information about every field on the island currently. And a lot of that's going to be down to the ability of the resource in the department, the way we administer the agricultural returns that we ask for on an annual basis. In the old days were very much more detailed than they are now. We had a lot more information, but although it was hugely time consuming to collate it all. But I think we can do better with modern technology, data collection, computers, spreadsheets, that type of thing. We should be in a position to do better.
Do you think it is your role to use the powers, especially as to approving or refusing the lease or sale of land, to best foster the agricultural industry? And again, explicit comments from the dairy industry have said that they've lost access to some of their most important pasture land because neighbouring houses have purchased land and they don't want cows on it. And that's within your gift to protect the industry, and it's actually your duty under the law. Do you think it's right to use the powers you have in the law? Once you've got the evidence,
there's two sides to everything, but I accept what you're saying, and certainly I think there have been ways found to remove agricultural land from mainstream agriculture, can we say? But generally speaking, there's always, I'd like to think, ways around solutions to these problems. And I know very many people who may say, I don't necessarily want cows in my field, that's fine. But actually the grass in that field is just as useful to the dairy farmer if he can harvest it and ensile it or turn it into hay or what have you. So there are compromises, but there are large areas of the island now which are becoming maybe that's wrong, not large areas. There are areas of the island which are becoming unfarmed, or properly or unproperly farmed, if that's a phrase I could use. And we need to look at all that and see how we're going. It may well be that when it comes to land classification, we need to think about a piece of work which identifies different areas of the island as agricultural priority. And it may well be that into the future we want to be thinking a lot more about woodland, about biodiversity, about carbon, about a whole range of other things, because that is part of the way that the countryside of the island can contribute to the future.
Thank you. Minister, Conor.
No, I was just saying,
Okay.
finish, thank you.
Okay, no, thank you. And looking at the time, there's kind of two more areas that I really like to focus on because they're part of your legislative kind of priorities that you've identified for the remainder of this term, though we have many other questions for you in areas. But you're responsible for bringing amendments to the regulation of care law 2014, and we had a briefing in December that stated that the amendments would be lodged imminently, but we have not had that. Could you give an update to where they are?
I had, after that time, I had further discussions with the Health Minister about the introduction of, regulation of hospital and ambulance service. And we had a number of discussions about that, and one particular area that he and officers wanted to focus on is the level of responsibility for individuals within the regulation system. And I think we've come to, if I remember correctly, to a conclusion whereby the Minister is going to be now held responsible. Initially, I think the regulations were going to say the chief officer.
Yeah.
There were some issues there, but the Minister is now going to be held responsible in his corporate.
Yes, I think we've seen the MD.
Yep.
What's
So
next?
that is still to come back, and as soon as it does, I'd like to move forward because I have a number of other things I'd like to be doing with the Care Commission. We've been planning for this work. It's budgeted. We've been talking to the people in the UK who are going to do the inspections for us, not run the system, but to inspect for us. We're all sort of programmed in for this year. But if we can't get this, if the legislation doesn't come up soon, we may be missing that.
So it's still to bring amendments for both the hospital and the ambulance
Service, that's correct.
And when we're talking about the hospital, we're talking about the current one and the future one?
Yes,
or
we've
we
had
cover
discussions
everything?
about, I can't remember who it was, but somebody did suggest that maybe we should be waiting for the new hospital to be built. But in the discussions I've had with the new chair of the Care Commission, because we've recently appointed a new chair, we very quickly reached the conclusion that the Care Commission can be of real help to the Health Department in setting up the way this new hospital works and discussing with them about how it operates and how it might be regulated. And while some people might be quite worried about us regulating the old hospital, because as we move towards the new one, the regulation of the old one, to my view, is quite important. I think the Care Commission can really, a bit like a scrutiny panel, they can work with the Health Department to make sure that not only does the old hospital function as best it can under the circumstances, but the new hospital, when it's built, really, really runs as best it can do. And so I have, encouraged the Health Minister on the basis that he should see the Commission as a critical friend rather than somebody who just wants to, be very, very difficult.
So are we going to see these soon to be lodged just from
I'm
panel
hoping
work plan?
so. I have to say that I haven't spoken to officers about this in the last few weeks. Certainly we have had, we have a proposition in the States about further regulation of counselling services, which is something we're addressing, and we'll respond to that as well. But in the initial short term, hospital, ambulance service, and I really hope we can get that over the line this year because we said we were going to start and we do need to start. I think it's important.
Thank you, Minister. And the other one on your list is the food Jersey law. It's something that you have mentioned to us in a letter that you confirmed that you're aiming to get this by the end of 2025, early 26. is this still standing, knowing that we've just had a very big discussion on many other areas?
Yes, well, it's one of those areas that we really, really want to get sorted out, and the industry themselves are very keen for us to do this work. So that we're pushing it an open door in much of this. We're working hard. Drafting instructions have been issued, and it's every indication that we're going to get that through as well this year. And while you might say we've seen nothing so far, I think it's really important that we address all the different facets at the same time. So there's no point in having some rules and regulations about what goes on in the restaurant itself without some rules and regulations about what's happening in the kitchen, so make sure that the allergies and all that sort of thing are addressed. It's important to make sure the ordering the food comes through in a way that chefs can be confident that the allergies and that sort of things are. And finally, because the most important thing is to make sure that we as a department have the ability to go in and take action if chefs and restaurant establishments are not doing what they should. So there's a number of different things there, and rather than just go one at a time, we're going to bring the whole lot in one hit, because I think, as I said, the last bit, the regulation, having the ability to take action is the most important, because no point setting it out and then not, doing
I
it.
could just add, just in terms of the timeline, as Ms said, law drafting instructions are in, so we will have a draft regulation for public consultation by summer.
And again, you'll have that as soon as we got it.
Thank you. And I think perhaps one of my questions was about enforcement mechanisms, but I suppose it still sits in the same pattern as what regulation do anyway at the moment with public health, or with environmental health, I mean.
The new food safety law that was approved by the Assembly did introduce more enforcement powers, because at the moment it's quite an extreme prohibition notice to the Royal Court. So it does allow sort of better provision for notices to be served rather than immediately to the Royal Court.
And there is going to be an introduction of a new border control regulation and a new border control post in Jersey. Does this have any effect on food safety inspections?
Well, certainly one of the main reasons for the new border restrictions is to do with food and to making sure that we can keep people safe, the food that gets imported onto the island. There are some discussions, we've made provision for some new border controls and to be set up for animals, food and a whole range of things. We're sort of being led a bit by the UK, and I think it's fair to say that they've flip-flopped around a bit with where they are and how they're trying to do things, but certainly from a sanitary and phytosanitary perspective, we're moving ahead. We have the resource and the finance to put the facilities we need at the harbour, and we are going to start soon inspecting food, especially the ones that come in large.
Products. It is more important to note, within the food safety legislation, there is also controls for imports and exports from a hygiene and safety perspective of food. So it's not only for border control and the official control regulations, it is also for food safety.
Great. And in that, do you feel that you have the resource level to be able to implement this work stream?
We are budgeted. We have some challenges, like everybody else has, with finances, but we've been expecting this for a while, and I think we're going to have to do it. It's something that's coming forward, and we will find a way to pay for it, one way or the other. There may be some charges, there may not be some charges, but obviously if we're not going to charge, we're going to have to find a way of paying for the services we provide from inside the department, which in itself will be a challenge. So, we hope in the next 12, 18 months we'll be up and running. May not be quite as widespread and broad as we would have hoped of initially.
We would risk assess inspections.
But some of the veterinary stuff is starting to appear as if it may not be quite as draconian or difficult as it would have been initially. I think I might, with where the UK rolling back on trying to make it maybe a little bit easier than we first thought. I can't remember.
And just, you said before, and this is my last question, about industry, you're pushing an open door. Is that, have you've consulted with industry, they feel that this is something that can be done from their
Well,
side. They don't see it as part of this concern about red tape.
Not necessarily. I think there's two very quick things to say about it. The first one is we're way behind the UK, and I think any responsible food establishment realises that we are. I think we're way behind, and they are already abiding by rules that we haven't yet set, because they want to be able to show to their customers that they take all these allergies down, all that type of thing, really seriously.
For the sake of clarity, we are talking about the food safety legislation, not the OCR.
Yes,
Yes,
food
the food
law.
safety, the food law, and
law.
food safety
Yeah.
law. Yes, so in consultation with Hospitality Association, and there was obviously an allergens conference recently. It is in the whole community and industry's best interest to have up-to-date and fit-for-purpose legislation.
And many people in the industry are very keen. You know, they're the ones. Some people within the industry are telling us get on with it as much as members of the public.
Yes, thank you, Minister. And we've come to the end of our 2 hours, and there is a number of areas that, you know, and we recognise that your work stream is large, because we haven't been able to cover those areas. For example, the rented dwelling licence scheme update for that, the tree protection, and they're listed, and I know in the hearings you said, our last hearing, that you're reviewing criteria, and then of course the carbon neutral roadmap and kind of updates on all those areas. So we will be coming back to you with questions on those, and maybe in the next hearing focus in a bit more on some of those areas that, as we see going forward.
Yeah. Well, I can tell you, in a very, very couple of real headlines, if you want. We initially thought we might have 15,000 rented dwellings. We're just over 18,000. And what else would I like to say about that? We promised we would repay people who had registered for, the star rating, and that's concluded now. Those days have gone back, and the scheme is now sort of up and running. And we're still having a steady little stream of people registering new properties every month.
And we are close to publishing the second version of the Codes of
Oh
Practice.
yes, still working well with the JLA. I'd like to thank them for
We have over 80
helping us
changes.
out. Yeah,
Will Scrutiny get a copy of those updates before they're published?
yeah, no reason why not.
Thank you, that would be
appreciate a chance to.
appreciated.
And we will be publishing an annual report when we get to the June, is it?
Yes,
June,
so
July?
the scheme running from May. So May to May, the report will be lodged at the Assembly in June.
Okay, well, thank you, and then of course we'll follow up with tree protection and carbon neutral roadmap afterwards. So I'd like to thank the Minister, Assistant Minister, for attending, and of course for attending this hearing, and for addressing all the panel's questions, wide-ranging as they are. And I'd like to also thank the members of the public for listening and for viewing this online, and those that are in the room as well. So thank you.